today, what we're going to try and resolve is the webinar is for any person that has property or other assets in Spain. In other words, if you haven't got any assets in Spain, then this webinar is not for you, because if you don't have any assets here, you don't need to make a Spanish will. Okay, we point out that we enjoy the challenge of handling complicated probate cases for expats, but this is not in your best interest. So to avoid having to pay a lawyer in Spain to deal with a challenging case, watch this video and we'll tell you how to avoid that. It's about keeping inheritance simple. And you'll see here that I put here, I will have with me 2 other lawyers from a fantastic firm in the Valencia region. Well, that's Ignacio and Pedro that have not arrived yet, but hopefully they will join us, even though maybe when we're halfway through. Okay, so let's dive straight in. First question we get very often is, do I actually need a Spanish will? Okay, well, the answer to that, without any doubt, is yes. Okay, it's not that it's impossible to deal with an estate without a Spanish will, but it will cause lots of problems, and I'm going to explain this on the next slide. Okay, so that's our categoric affirmation. This is Michael Davies speaking, that's me. I deal with lots and lots of probate cases. I've been doing this for the last 25 years. I've dealt with between 400 and 500 inheritance cases for expats, and I can say categorically that you must make Spanish will. It is in your best interest. Most other solicitors that I know will all tell you exactly the same thing as what I'm telling you now. Okay, what happens if there is no Spanish will? Okay, we can be in different situations. One, that there is a will in England that deals with worldwide assets. Okay, the inconveniences can be many, but just let me explain that even in the best case scenario, that English will need to be convalidated. It needs to be made valid for use in Spain. So that you cannot convalidate the actual will itself. You'd have to take that will, go to probate in the UK, and then convalidate it with Hague's apostles, official translations, and eventually you'll end up with a document that you could use like a Spanish will. The problems, there can be many. Why? Because the English will has been made by a lawyer in the UK that, of course, is not thinking about Spanish inheritance tax, so it will not be efficient from an inheritance tax point of view. But more than that, sometimes there can be very serious problems to convalidate the will. Let me just give you one example. There are many, but the one that causes lots of problems is if you mention the word trust on the English will. Now, the reason for that is that trusts, as they exist in the UK, do not exist in Spain. So the convalidation is very complex. And exceptionally, it can be so complex that it cannot be resolved. That is exceptional, okay? But it can happen, and it does cause, in any case, lots of expenses, lots and lots of delays, and it can cause serious problems with the inheritance tax office in Spain. Because, for example, in Spain, the beneficiaries pay more or less tax depending on their relationship with the deceased. So children and spouse get a very, very good deal, and strangers do not. So if, for example, you have created a trust on the English will, and the beneficiaries are the children, but say, for example, that the trustees, the people that can actually do things with the trust during its lifetime, are not family members, the Spanish tax office may consider that the inheritance cannot be considered as being received by the beneficiaries because they don't have control over it. And therefore it's being received by this entity that they would then put in group 4, and that is they get the worst inheritance tax treatment. Conclusion, dealing with an English will, if it mentions the word trust, is disaster area. There can be many other problems with English wills and the convalidation, but simply stay away from that. It's not a good idea. Don't trust your English will to deal with your Spanish estate. The other thing we can come across is there is no will anywhere. Okay, if there's no will anywhere, if the deceased was a resident in Spain, then we'd have to go to an intestate procedure in Spain. The problem with that, much more expensive than dealing with a will, much longer than dealing with a will, And also you may end up with the beneficiaries not being the ones that you expected, because in Spain, the lion's share of an inheritance of a person that's resident in Spain who deceases is not the spouse. The lion's share goes to the children. So big problems there. And if it's intestate, but they are non-residents, we cannot go for intestate procedure in Spain. It have to be done in the UK and then convalidated. And then we have similar problems to what we mentioned on dealing with an English will. Disaster area as well, don't go there. There's also another problem with dying intestate, and that is that because of Directive 650/2012, if you don't make a will in which you mention that you choose English law, not the English will, English law to determine how you can distribute your estate, automatically, if you're resident, they will apply Spanish law, the Spanish law to how you are allowed to distribute. And the Spanish law has a system of obligatory heirs, which makes it basically means that the children end up with the lion's share of the inheritance and not the spouse. The inheritance tax problems when there's no Spanish will, we've already mentioned them. And as I say here, many other problems. I've just given you a couple. Basically, I've got no doubt. Make a Spanish will. What can you achieve with a well-written Spanish will? Okay, the first thing is that you will manage to protect the people you love correctly. For example, you may have a situation where you have, for example, most couples will simply want to leave everything to each other and then down to their children. English people can do that without any problem, but when they make their will, they have to say on it that they choose the English law to determine how they are allowed to distribute their estate. And then they can go on and do whatever they want. For example, everything to each other and then down to the children. If they don't make that affirmation on the will, a Spanish obligatory heir system would apply, and 2/3 of the estate would have to go directly to the children. That's been law in Spain since Directive 650/2012 that came into force in 2015. So if you've made a will before 2015, but definitely it's been made before 2012, it probably does not comply with the directive, and you'll need to update it by going to the solicitor that made the will originally, or going to a new solicitor and doing a new will and revoking the previous one. Okay, so there are many ways in which in Spain we can protect our loved ones. For example, let's say that you have a situation whereby you have children from a previous marriage. You're married to your second wife, and you want to make sure that if you pass away, your wife can live in your villa in Estepona, Marbella, Mojaca, or wherever. But you don't want her to be able to dispose of the asset, because in the end, you want your children from your first marriage to end up inheriting at the end of the day when she passes away. Okay, okay, I can see that Ignacio has just joined us. Welcome, Ignacio.
Hello, Michael. Good afternoon. Sorry to be late. I apologize for that.
No problem. I'll catch up with you in a second. I'm just going through the slides. The one we're on at the moment is what we can achieve by preparing a well-written Spanish will. Okay, we'll catch up in a second.
Okay.
I'll just show this.
No problem. Go ahead.
So if we have this situation, children from first marriage in Spain, it can easily be dealt with by leaving the life possession to your wife and the residual value of the asset directly to your children. Some people come to us saying, well, can they set up a trust to deal with all these things? No, you can't. In Spain, trusts don't exist as they exist in the UK. And if you decide, well, the Spanish lawyer can't do what I want, so I'll go and do a will in the UK, and later on in probate they can convalidate, that's completely the wrong option, because we've got all the problems of convalidating the English will later on. Probate, yes, if you make a Spanish will and it's a normal Spanish will and it's in good order, there is no reason for probate in Spain to take more than 3 to 4 months. In our office, for example, on the wills that we do, we guarantee that the probate can be done on them within 4 months. Inheritance tax efficiency. If you go to a lawyer in Spain that's used to dealing with expats and he's an expert, he will be able to tell you the most tax efficient way of leaving your assets. There may be a trade-off with what you actually want to do, but it's a question of discussing it all with the solicitor to try and basically achieve a will that's tax efficient. In most regions of Spain, the inheritance tax for Group 1 and 2 beneficiaries, that's spouse and children, is very, very low. And in Andalusia, for example, it's exempt under €1 million. So if you have a villa worth €3 million and you divide it between 3 beneficiaries in Group 1 or 2, for example, spouse and 2 children, if you divide it up, they each have an entitlement of €1 million exemption, so it could be tax-free. The exemptions at the moment are very generous in Spain. Inheritance tax problems when there is no Spanish will. Well, I think you can guess where all that leads us. Basically, as we said before, we're dealing with an English will, mentioned a trust. All that can lead to a lot of problems with inheritance tax office in Spain. Many problems, as we say. Okay, let's go on to the next slide. We've done that. Okay, and at the end, we're going to go through the 11 tips to make a good will. But before we dive into that, which is probably the most important part of the webinar, I'm just going to ask Ignacio if he can tell us about any nasty experience. Ignacio Pellicer has a law office in the Valencia region, and they deal with a lot of estates. And Ignacio, out of curiosity, you've had a lot of experience. Could you give us an example of a situation where the non-existence of a decent Spanish will, or one that's been wrongly written or not updated to directive, has caused problems for your clients? Problems or expenses? Problems, expenses, or delays? Could you give us an example, of course, without any names?
Yeah, Michael, you're fully correct. I mean, as you just said, it's always very important to have a proper will drawn up and written properly, because the amount of problem could bring not having a will, or even a complex will that is not very well drafted, it could end up into litigation, Michael. And that's, well, that's one side. Going into litigation is one side. The other side is probably not even able to make it happen, because not having a will makes things a lot more complex. Even having a will that is not good enough, it could end up into contesting wills and problems. And yes, Michael, we dealt with a lot of international clients, and you could imagine the applicable law depending on their nationality and the situation, even what type of law will apply. And it could have been sorted, Michael, with just a proper will, which... Yeah, I can tell you.
Yeah, I absolutely agree with that. I mean, at the end of the day, okay, I mean, we're experts. In my case, I deal mainly with inheritance work, and I've done so for many years. But at the end of the day, making a good will is not rocket science, but there are 3 or 4 things that have to be done correctly. And mistakes are made, unfortunately, and we do come across serious mistakes. The biggest mistake, though, in reality, is simply that people that have not made a will. I mean, that is probably the one that we see most often. Sometimes we see wills prepared by lawyers that are not maybe as tax efficient as they should be, or they have not been designed sufficiently well to avoid a claim from the children against second wife and things like that. But you know, at the end of the day, normally the wills, you know, of a couple that's moved over to Spain and have got a property, a car, and a bank account. Normally, those wills, if they're done by a lawyer, normally they work out well. It's a question of so there's a big difference between not having a will and having a will done by basically any lawyer that sort of deals with English clients and things like that. If you've got one of those, you'll probably be okay. Probably better if it's done by a specialist, but you'll probably be okay. The biggest mistake, not having a will. The second biggest mistake we see recently, Ignacio, are wills that have not been adapted to Directive 650/2012, which came into existence in 2015. And we have the situation where, you know, the widow comes in to see us, she brings her husband's will, and then we find out by surprise that he made the will 15 years ago. He simply made a will leaving everything to his spouse and then down to his children. And then And then what we find is that the will does not specify that he chooses his national law to determine how he's allowed to distribute his estate, causing all sorts of problems because, of course, the children may be called to inherit instead of the wife. And that we're seeing a lot. So the solution to that is simply to speak to the lawyer that prepared it and quickly go through it to make sure, see if it adapts or not, and otherwise make a new one and revoke the previous one. And then the other one mistake that we see a lot, Ignacio, is when we're convalidating English wills that I was mentioning on one of the first slides, how the convalidation of an English will causes, in all cases, more expense, timescale, and all these things. But often the English will mentions the word trust. And I was explaining on the first slide that basically is the recipe for a disaster. The business of the trusts causes lots and lots of problems in Spain. So that can be avoided by making a Spanish will. The other thing that we've seen, Ignacio, is people by mistake revoking, for example, because we always recommend make a Spanish will for Spain and an English will for the UK. And they end up revoking, for example, the English will when they make the Spanish will, because the later will revokes the previous one unless they specify that it's only for Spain. So if you put the clause in saying it's only in reference to the Spanish estate, so it ends up revoking the English one. We've also seen it the other way around. An English will they make a Spanish will 10 years ago, and then last year they're back in the UK feeling poorly, going to make a new will, and they say it's for worldwide assets, and they end up revoking the Spanish will. So the situation, the probate in Spain, which would have been simple on the Spanish will, we end up having to use the convalidated English one because it's of a later date and it's for worldwide assets.
I completely agree, Michael.
Sorry.
I completely agree. I mean, the amount of problems people could have for not just doing things correctly with a proper will, with a specialist, are tremendous. And probably some people just say, well, no, I'll just do it this way or easy way, or you don't need it or whatever. I've seen so many. And to be honest, Michael, we've got now, don't ask me why, a lot of litigation problems with regards to inheritance. And obviously, as you know, is because everything starts with either not having a proper will or having conflict of laws as well, trying to use one or the other, not being clear, or just of children not being happy, Michael.
Yeah, I mean, we've even seen, I don't know, up in the, I mean, we work in Andalusia region, as you know, but maybe some of the people watching don't. We have offices in Jaca, Marbella, and Almeria. Ignacio has offices in Alicante and Javier, up in the Valencia region. I don't know if it happens up there, but here in Andalusia, we've even seen wills that have been prepared by a translator. And when we've gone to probate, we found terrible mistakes on the will. Yeah. And of course, the normal solution would have been to sue the solicitor that handled the will because it was an obvious mistake. And the client even had doubts about whether the person was a solicitor or not. And in the end, it resulted that they weren't a solicitor. That in fact, the only qualification was as a translator. And they just completely stepped out of the problem and not affected them, and left the client with a very messy inheritance procedure.
That's terrible, Michael.
Do you come across that? Do you come across that in
and I fully agree that this is a terrible scenario, especially because you end up in a situation where the problem, you will pass it on to the beneficiaries. That's the last thing you want to do. Now, having a translator, he could translate a few things, but cannot really go into the specific of the law, applicable law, conflict of law, contesting wills, executors, tax efficient. So Michael, the worst thing somebody could do is use a translator. You think it could be cheap because you just pay just a translator, but you're not paying for expert advice. And at the end of the day, you will pay, unfortunately, one way or the other.
I mean, the money spent on wills, I mean, as in your case, I imagine that you probably make a lot more money in your firm on dealing with inheritance and the complicated ones, especially. While the wills are something that are relatively cheap, well, not cheap in relation to how important they are. They're not expensive documents. I mean, in Andalusia at the moment, most of the lawyers that we know are good and do things well. They all charge anywhere between 200 and 300 euros plus VAT for each will, and then the notary charges about 50, 60 euro to witness it. Are the prices similar up in the Valencia region, Ignacio?
Yeah, Michael, I think that's about right. And as you said, a starting point, that's more than reasonable. And I consider it is not a lot of money to have expert advice, because the amount of time we spend doing a proper job, you know, is a lot of work. But I understand as well that when it's complex, could be even more. I'm sure in Andalusia happens the same. Depends on the amount of hours if you need to draw up a complex will.
Yeah, and I was just also, in addition to the possible very serious problems and the possible serious inheritance tax complications, in a normal scenario of probate, I mean, for example, on wills that we've done, and sometimes on wills that are brought into us to go to probate, on all ours, often on the others as well. I mean, we guarantee in our case on our budgets that we can wind up the estate in 4 months. While whenever we've got a situation where there's no Spanish will, it is very difficult to put a time scale to how long it will take. And we always say that dealing with probate when there's no Spanish will always cost a client at least double than it would if you had a Spanish will. That's what and the time scale cannot be established. Would you agree with that sort of as a guideline, perhaps?
Yeah, Michael. I was just even thinking about, I mean, sometimes it's very difficult, and you will think it's so difficult to budget problems, isn't it? Because when you face problems, how many hours, Michael, are you going to spend on the case trying to sort out something that you could have sorted out with one visit, with one...
Absolutely. So that's the other problem. Yeah, so the other problem is that with those situations is that if you've got one of the situations with no Spanish will, you basically, at the end, the lawyer will be offering you a budget. It will not be a closed budget because he can't close it because he doesn't know where it's very often difficult to know where those cases will lead. While if you have a Spanish will that it's in good order, a normal title deed, a normal bank account, and perhaps a car in your name, any lawyer that deals with probate on a frequent basis will be able to budget the work exactly from the beginning. So there's no doubt it's a good idea to make a Spanish will. So my last slide, Ignacio, is we're going to go through 11 tips to make a good Spanish will.
Good.
I'm sure there will be a few more, but these were the first things that come to mind, basically based on the mistakes that I see. And I think if we keep to these 11 tips, you can still make some mistakes, but I think if everyone did at least cover these 11 points, the wills would be much better in general than what they are. So let's go on to the next slide. Let me just see if I can master this. Let's see.
Yeah, that's perfect.
Okay, so here we go. It's a bit small because there's a lot to it. Okay, so the 11 tips. The first one is, without any doubt, make a Spanish will. So that's the first mistake to avoid. Make a Spanish will. If you've already made one, you need to make sure that it complies with Directive 650/2012 that's been enforced since the 17th of August of 2015. If you have any doubt about what I'm saying, simply Google Directive 650/2012 and you'll see that all the lawyers in Spain have written about it at some point during the last few years, and they will all explain the same as me, and that is that you need to make sure that your will complies. If it doesn't, you need to go into the notary and make one that does comply. Okay. Oops, let me say. Okay, 3. We mentioned here, if you have children from other marriages, and you want to protect your wife now, and at the same time protect the situation of the children, that happens quite a lot. Think about dividing up life possession and residual value. Spanish people use this system a lot. We use it with lots of our Spanish clients. It sounds a bit of a foreign terminology for English people, because in England this doesn't exist, the same as trusts don't exist here, but speak to your lawyer about it if what you want to do is protect children while protecting your second or third wife. Okay, the next thing is number 4, make sure you understand the advantages of sentence of 3rd of September 2014 of the European Court of Justice. This is the sentence that I'm sure you've applied it many times in your practice and inheritance. This is the one that allowed non-residents who are resident in the EU to claim the regional exemptions that up to then only existed for Spanish residents. It's a bit of a long story, but just make sure that when you talk to your solicitor, you talk about this sentence. Okay, we also we talk about think about the life possession and residual value as a possible method to mitigate inheritance tax if it's applicable in your case. Also, to make sure that your will is up to date. In other words, not only does it need to be up to date with Directive 652/2012, which is a one-off, but also to realize that during the last 7 years in Andalusia, they've changed the exemption rates 4 times. In Murcia, they've changed them twice, and I think in the Valencia region, they've changed them a couple of times as well.
Yeah.
So it may require that you change your will to make it more tax efficient, or in the case of Andalusia, where in the past we may have complicated the will to try and avoid what was then very heavy inheritance tax. It may, because of the higher exemptions that we have now, we may be able to make a will that is simpler because we're not so concerned about inheritance tax. So just make sure that your will has been revised in the last 2 or 3 years. Make sure we're sense of point of view. Okay, make sure the will is sensible from the point of view of inheritance tax and understand the effect of being or not being a non-resident on what has to be declared in Spain. People don't realize that if a beneficiary is resident in Spain, he has to declare what he receives worldwide. If he is a non-resident of Spain, he only declares what he receives in Spain. Okay, normal families will not normally pay inheritance tax in many of the regions of Spain. For example, in Andalusia, the exemption rate for group 1 and 2, spouse and children, is €1 million each. Just to take into account the different ways of distributing your estate between your beneficiaries can change inheritance tax substantially. Okay, this is an important one. I'm sure you agree with this, Ignacio. Do not make a will that is unnecessarily complex. What we see here is a lot of, because all the conveyancing lawyers do wills, they always offer the wills, there's nothing wrong with that, but not all the lawyers that do conveyancing deal with probate. So if you're going to enter into a complex setup with your will, ask the solicitor straight out whether he's ever gone to probate on a will with those specific clauses. Because we've seen setups that look really very good on paper, but then in practice, when you go deal with the actual probate procedure or deal with inheritance tax deriving from the probate procedure, some of those complex wills can cause delays when we're dealing with probate. Number 10, never mention a trust on a Spanish will. It will be a disaster. Okay, now we've got the situation of no Spanish will, and you have an English will that has to be convalidated that mentions a trust. But we have even seen the situation of somebody insisting to their lawyer in Spain that they wanted to do the same will they've done in the UK in Spain. And for some crazy reason, this person, whether he's a solicitor or not, I'm not certain, allowed them to go in front of a notary in Spain and sign a will that mentioned a trust. Now, this is just absolutely crazy. It's difficult for it to happen because normally, even if the person advising preparing your will isn't sensible, or perhaps is not a solicitor, normally the notary would be so surprised by it that he would mention it at the notary and avoid the signing. But we have come across one that was written in this way, and we're still trying to resolve it today, 4 years later. Make sure your solicitor has plenty of experience with probate and the Spanish Inheritance Tax Office. If he has not handled probate before, at least a few cases, he may not be the right solicitor to prepare the will for you. Or at least if he has prepared a will for you and he wasn't very experienced, make an appointment with someone that's got experience with inheritance and just run the will by them to see whether it's all in good order. Any more tips, Ignacio?
Yeah, I would like to add, Michael, here, just for the peace of mind of clients. There is nothing wrong I have against translator or historias or these kind of people. But at the end of the day, you see a lot of problems that couldn't be avoided. My recommendation, as you stated, try to go and look for expert advice. And what Michael says is completely correct. Make sure the person who's going to draw up your will has got enough experience to deal with it, as Michael said, in front of the tax office, or even if there is any contesting possibility of the beneficiaries, because enforcing the wills is quite complex. So the person who needs to draw up a will needs to know all possible scenarios in the future and be able to do the job you've committed, or basically perform the way you just wanted. Michael, and it's quite frustrating seeing terrible scenarios where no will, I agree, is a big mess. Having wrong will is not very good, I would say. And then at the end of the day, you could prevent all these possible scenarios. And that's why you will draw up a will with somebody who's a specialist. So Michael, my very latest tip will say, go to a specialist. It's not that the other people will not probably be incompetent, but they will never give you as much value as you deserve for what you want. So that will be my tip, Michael.
Very good. Excellent. Okay, Ignacio, we've got a couple of questions coming through. Mr. Peter Pasco, can I use my English will for probate in Spain? Can I set up a trust in Spain to deal with my estate? I would like my second wife to live in my villa in Marbella until she deceased. It must be psychic. Or maybe he didn't hear the first part of the webinar. Yeah. I would like my second wife to live in my villa in Marbella until she deceased, but I wish to make sure that when that happens, the children from my first marriage inherit the villa. Okay. Do you want to take that one, Ignacio, or do you want me to answer it? What do you prefer?
Well, just go ahead, Michael, and I could just jump on it.
Okay. Well, first thing is, can I use my English will for probate in Spain? Of course, theoretically, yes, but that's not advisable. You need to make a Spanish will. Can I set up a trust in Spain to deal with my estate? And then he explains what he wants to do with the trust. Well, the answer to that is no. You can definitely not use a trust in Spain, and you don't want to use a trust. What you need to do, the life possession residual value divisions that we have in Spain, which are used here instead of trust, is the perfect scenario. So if he has a second wife, he wants to make sure that she can live in the villa in Marbella forever if he passes away, but he doesn't want her to then leave the asset to somebody else and leave the children from his first marriage out. It's very simple. He should make a will. He leaves the life possession of the villa in Marbella to his existing wife, and then he leaves the final ownership directly to the children. So that means she's protected. She has a title deed that says that she's got the right to live there for the rest of your life, and it's actually a title deed, and it's registered in the property register. And the children will have the security that when she finally dies years later, they will simply consolidate the ownership by presenting her death certificate to the property register. It's the perfect solution, and we use it all the time for this scenario. We don't have trust, but we do have this. Peter's also asking one more question, and that is, how much does it cost to make a will in Spain? Okay, well, I don't know exactly what everyone charges. In my particular case, if he came to me and it was a will for him, just him on his own, in this case, for that will that we're talking about here, so he's talking about a villa in Marbella. He must have a bank account for direct debits, maybe has a car. For that will, and dividing up the life possession residual value, for that will, we charge €300 plus VAT, and the notary in Marbella that we use normally charges about €55 for witnessing. Would that be around the same up in your area?
Yeah, Michael, that's exactly what we charge here in the Alicante. The only thing you could vary, I don't know if you come up, is the notary. Sometimes you could end up having a bit more in one notary office or the other.
Yeah, curiously enough, it's strange things happen with that, because I know up in your area you have notaries there. They're quite expensive for some reason. I
Yeah,
don't know why.
yeah, that's
And yet,
right.
would you believe that the notaries in Marbella for wills are cheaper than the ones in Almeria?
Yeah.
I don't quite understand. The notaries that we use in Almeria to witness the wills normally charge between 60 and 70. And the one we use in Marbella, in central Marbella, charges between 40 and 50. At the end of the day, they're not big numbers in any case, because all the notary does is to witness and register the will. But that's just so basically, I mean, we always say that basically a married couple, the wills in total come to about €500, 600 euro, notary, registrar, etc. In this case, it's one person on his own with the slight complexity of life possession. In our case, it would be that €300 plus VAT, and the notary around €50 because it would be signed in Marbella. Okay.
I could just say, Michael, here, that with regards to the notary here, if you go inland, you end up having a set of rules. If you go in another area, you've got even 100.
Yeah.
But at the end of the day, it's not a big deal, because you could go different notaries.
Yes.
And sometimes it's convenient depending on your.
I know in Almeria and Mahaca, the wills are always between 45 and 70 euro, because we've got the notaries. I know up in your area, there are places like Javier where I know they're very expensive. They charge about 100 or 110 euro.
Yeah.
I think the notary's close to retirement, and he doesn't seem to.
That's in Morara, actually.
He does a good job, though. He does a good job. So anyway, but in general, though, I mean, I know Alicante Centre, they're a bit cheaper. Javier.
Yeah.
Anyway,
that's right.
The best thing is just to ask your solicitor for a budget in writing. I mean, we always provide a budget in writing for what we're going to do. Okay, I have another question coming through on Facebook, Ignacio, and it's related to the wills, and that is they're talking about that they've heard on the grapevine that as you get old, powers of attorney may be good, and how can they be used, and what would they use them for? Why would they need to sign them? Do you want to go for that one, or do you like me to explain what we tell our clients about the powers?
Yeah, you go, because in Andalusia, probably you go first.
Okay, well, the way we do here when we have, say, a couple that's over 70 or over 80, often they come in and they're not asking specifically about wills. What they want to do, basically, sometimes they come in with the family, especially as people get older, and they sort of say, the question is sort of something along the lines of, well, we just want to sort of see what we have to do to make sure that things are as organized as possible. When somebody comes in with that, we talk to them about three things. The wills, which is what we've just spoken about, which is the most important. That's 99% of the importance. But we say that also, if they're getting older, say they're 70 or 80, to do total reciprocal powers of attorney between the spouses is not a bad idea. And if it's one person on their own, then perhaps to a couple of their children. Why do we say this? Because as people get older, they're here in Spain, let's say that one of them, for example, either mentally or physically becomes unable to visit a notary, visit the bank, or they have a little bit, they've just been diagnosed with Alzheimer and things are getting a bit, they've still got consent, they can still go to a notary today if they wanted to sell their property, because they've still got consent, but they've been diagnosed, so they're worried about the movement going forward. What we recommend is that they grant each other total power of attorney. And that is so that if, for example, let's say, for argument's sake, let's hypothetical names. Joe and Mary, both in their 80s, and Mary's just been diagnosed with Alzheimer, for example. But she's still okay. She's still, you can talk to her normally. She knows exactly what she's doing. We say do powers of attorney. Why? Because if Mary later on, 7 or 8 years' time, gets much worse, and suddenly she needs to move to a home, or they simply need to sell the property to go back to the UK, if by then she is in the state mentally, she is not able to grant consent, the notary does not feel that she's well enough to know what she's doing with the signing of the sale, they could be trapped into not being able to sell the property because nobody can sign for her. Well, if the husband already received a power of attorney 7 or 8 years ago, that's simply brought out of the drawer and used then so that the husband can sell the property and therefore they can keep moving forward. The reason for this is that unlike in the UK, where when somebody has got serious Alzheimer, you can go to the family courts and get it, and during power of attorney, after the person got Alzheimer, in Spain, the procedure through the courts to incapacitate someone and for the judge to name the husband as the person that can sign the sale can easily take a year or two, be very costly, and it's a nightmare with doctors' cross-examinations and all sorts of things. So the power of attorney is good for that. And the third thing that I always say is, if we're in that sort of situation, is I always say to them that it's not a bad idea just to go through their documents and make sure that the basic documents, someone knows where they are. For example, they need to know where their title deed is to the property. Put it in one place. Somebody needs to know where their bank accounts are. It's not necessary to know the bank account number or the branch, but you do need to know what bank. Banco Popular, Banco Sabadell, whatever bank. Why? Because at the end of the day, the solicitor that handles probate has got to know who he writes to, so the bank can then certify what's in the account, etc. But they need to know with what banks they work. Also, if there are car papers, take a photocopy of the paperwork to the car that's normally in the glove department and just leave all those documents together so that somebody knows where to locate them, or simply let the solicitor that handles the will copy or scan, as we do nowadays, all the documents so that he's got a full set of photocopies in his office of everything that's needed for probate. The power of attorney also, apart from it being granted to each other, if it's a couple, if it's, for example, a widow on his own or widow on his own, perhaps it's a good idea to get a couple of the children over from the UK, have a family meeting, and perhaps they should think about granting power of attorney to the son, to the daughter, or jointly to a couple of the children, in case later on that person becomes disabled, either physically or mentally. Also, if, for example, somebody is 80, decides to move back to the UK, but is not going to sell the property because of the market or whatever, before they go, I recommend they make a power of attorney to one of their children, so that later on, when they're 90, they don't have to fly over to Spain to sign the sale. They can just leave a power of attorney to either one of their children, or the children jointly to with the solicitor, or the solicitor to do something like that. Well, I think that's it. I think we've got everything covered. I mean, there are so many. The subject of wills can be is very, very broad. There's lots and lots of things that we could discuss.